Good morning, dear participant. I welcome all of you to our online seminar. Today we have with us our guest speakers from the YaPartners Consulting, the company active in the legal sphere. We will talk mostly about Russian countermeasures. It means the measures to the European sanctions.
Good morning.
Good morning. May you just please keep the microphone muted? Yes, thank you. Thank you very much. I would like just remind that we make a recording of the main part of the presentation, and then we will close the recording for the Q&A. What we just discussed that today there is already 11 package of different European sanctions against Russia, mainly in financial sphere, in the oil and gas sphere, and these sanctions not touch all the sectors, hopefully, of the bilateral trade and exchange. And for Belgian companies, especially for Luxembourgish and Belgian company acting in Russia or with Russia, and very important to also stay updated on the Russian side countermeasures, because they are no more published in English language. They are always published in the Russian language. And to better understand them, I let the floor to Marina. You will be the first, or Maria will start?
Yes, I will be first. Mm-hmm.
Then I let you the floor.
Mm-hmm. Yes, thank you very much. Good morning, and we are going to speak about Russian countermeasure, Russian counter sanctions or anti-crisis measure in Russia for foreign companies in Russia who is acting in Russia. So please, Maria, next and next slide. Okay, the legal landscape of foreign companies in Russia has become dominated by so-called anti-crisis or countermeasures, counter-sanctions measures. The purpose of such rulemaking is to mitigate the negative impact of Western sanctions and regulate capital outflow from the country. The basis of such legislation is the law on special economic measures, a law on security, and the law on measures to influence or counteract on unfriendly actions of the United States and other foreign states. Next, yeah. The Russian president, I would like to give an overview about this measure. And the Russian president, in accordance with the law, establishes measure of counteraction aimed to ensuring financial stability in Russia, economic countermeasures. In particular, these include prohibition or restrictions on certain transactions and operations, obtaining special permits, use of special accounts, sale of foreign currency proceeds, set of limits and peculiarities of the fulfillment of certain obligations, including offsetting or changing the currency of the obligations. At the same time, the president has a right to delegate certain powers to implement such measures to the government or the Bank of Russia. The Bank of Russia, in its turn, gives official explanations on the application of certain decrees of the president, as well as issues approvals to carry out certain transactions or operations. Such approvals or permits are issued upon individual request with respect to specific transactions. However, the Bank of Russia may also issue approvals addressed to all residents or a specific group of residents. In addition to the Bank of Russia, the Ministry of Finance provides official explanations on the application of certain presidential decrees. Also, official clarification of the Bank of Russia and Ministry of Finance are not normative legal acts. They should be taken into account when carrying out transactions or operations. Through the Ministry of Finance, interested parties submit application to the subcommission of the Government Commission for Control over Foreign Investment for approval of certain transactions with the participation of persons from unfriendly states. The Ministry, it's too early. The Ministry of Finance formalized the decisions of the subcommission as well. The subcommission is authorized to make decision on issuing permits for transactions with foreign persons from unfriendly states, as well as performing currency transactions. The subcommission, in turn, like the Bank of Russia, issues permits upon individual requests or to all residents or specific group of residents. And such decision or permits are published on the website of the Ministry of Finance. But in the financial and fuel and energy sectors, permits are issued by President by his orders in accordance with the Decree 520. Yeah, next. So the anti-sanctions measure relate to currency transactions. For example, there are restrictions on the transfer of foreign currency to their own foreign accounts with respect to dividends received in Russia, or payments of shares in foreign companies in unfriendly currencies in the equivalent of more than 15 million rubles must be agreed with the Bank of Russia, or mandatory repatriation of 80% of foreign currency proceeds and sale of 19% of foreign currency proceeds has been recently established for certain export companies. Or export of certain types of foreign goods outside the territory of Russian Federation is subject to a temporary ban or the need to obtain a permit from the authorized ministries.
Marina, may I just interrupt you 1 second to just say to our participants that unfriendly, it's a term. It's not means that it's a term which is used by the Russian Federation, because I received many times questions from our Belgian. It's just terms used by the Russian governments to design the countries which I think introduces the measures, restriction measures against Russia. Sorry, Marina.
Yeah. Thank you. There is, okay, thank you for clarification. There is a legal act issued by government of the Russia Federation. And with this act, a list of so-called unfriendly states was approved. Yeah, and it is this list includes all countries from European Union and also United States and also Japan and some other countries. So it's a term, yeah, it's term from the law on measures to influence unfriendly action of the United States and other foreign states. So then next slide, yeah, about unfriendly person. Yeah, in addition to currency transaction in general, anti-sanctions measures relate to transaction or operation involving persons from unfriendly states. Yeah, Belgium is in this list, for example. The restrictions and prohibitions mainly relate to transactions with real estate, securities, loan and credit shares, and in Russian companies, and payments of dividends abroad. It is important to know that Russian subsidiaries of companies from unfriendly states are residents of the Russian Federation, but in the same time are related to persons from unfriendly states. Therefore, transactions between two residents, one of which is controlled by an unfriendly owner, are subject to approval of the subcommission. Thus, in one case, the court invalidated a real estate sale agreement, and in another case, a loan in foreign currency and a mortgage agreement concluded between two residents, one of whom was under unfriendly control. However, for some transactions and operations, there are exceptions for Russian subsidiaries. For example, Presidential Decrees 1695 and so on, that exclude companies controlled by unfriendly person from the list of unfriendly person if the place of their registration is Russia. Yeah, so it's yeah, the next slide, okay. In particular, issuance of credit and loans. Loans to persons from unfriendly states require permission of the subcommission. But exception is when loans are issued in rubles to individuals secured by a mortgage, or a loan is issued to Russian resident under the control of person from an unfriendly state. In this case, the permission of the subcommission is not required. Or, next slide, or deals with real estate or real estate transaction. For example, real estate transaction with person from unfriendly states are subject to the approval of the subcommission. But even here, there are exceptions. For example, if the real estate is located abroad or alienated by foreigners for free, or foreigners acquire real estate or settlements through special accounts in Russia, etc. And such exceptions are established by presidential decrees and by decision of the subcommission, which are published on the website on the Ministry of Finance. The next slide.
Sorry.
Yeah, okay.
Yeah, so as Marina has already said, there are certain restrictions on the payment of dividends to foreign shareholders, to so-called unfriendly shareholders. And there is the basic rule that was established in 2022 that essentially continues to stay in force. So payment to unfriendly foreign residents may be made without restrictions if the amount of paid dividends or distributed profits doesn't exceed 10 million rubles per month, or the equivalent of this amount in a foreign currency. If this threshold is exceeded, then there will be two options. Either money can be paid to a C-type ruble account in a Russian bank opened for a foreign shareholder, or the permission of the government commission should be obtained. And there are certain conditions that should be made for government commission to grant this permission. For example, the amount of paid profits or dividend shouldn't exceed 50% of the net profit of the company for the previous years. Furthermore, the payment of profit for previous periods is analyzed and taken into account. For example, if the company haven't distributed dividends for years and suddenly tries to transfer all the money abroad, then probably government commission will be a little bit suspicious of that transaction. In addition, foreign shareholders have to demonstrate that they are ready to continue their commercial activities in Russia, that they are not going to leave the Russian market. After that, the opinion of the supervising ministry should be taken into account. In particular, this ministry should assess the significance of the company's activities and their impact on the Russian economy. Furthermore, foreign shareholders have to fulfill key performance indicators that also should be confirmed by the relevant ministry. And even in that case, the dividends or profits can be paid on a quarterly basis, provided that foreign shareholders continue to meet the key performance indicators. However, as of now, all of these conditions shouldn't be fulfilled and shouldn't be checked by the government commission if we are talking about payment of dividends to those foreign shareholders who, after the 1st of April 2023, made investments in the Russian economy, for example, expanded the production of some goods or developed the new technologies. In this case, there will be no key performance indicators and so on, but the dividends can be paid in the amount not exceeding the amount of such investments made by these foreign so-called unfriendly shareholders. Marina, could you continue?
I cut Marina microphone, apologize.
Yeah. Okay, yeah. So, and now about selling of Russian business with foreign participations. Yeah, the sale of foreign business continues. The current criteria were established by the decision of the subcommission in July and September this year. This is market valuation report, an opinion of self-regulatory organization of appraisers, a discount of at least 50% of the valuation, KPI indicators providing for, among other things, maintaining of technological potential and the main type of economic activity, maintaining of staff, and fulfillment of contractual obligations. Buyback option for 2 years, maximal for 2 years at market value, as well as settlement through special accounts in Russia or in installments. And also approval of antitrust authority if applicable. The budget contribution was recently increased to 15% of the valuation, irrespective of the discount. Previously, it ranged from 5 to 10%, depending on the amount of discount. And the contribution payment period has been reduced from 3 months to 1 month. So next slide. The shares may be forcibly placed in temporary administration by presidential decree or transferred to the state ownership or other persons by court decision. For example, the next slide, some companies, next slide. Some companies have been forcibly transferred to the state administration. So Maria, please tell about it.
Yeah, so as you probably already know, since April of this year, several companies with foreign shareholders, Russian companies with foreign shareholders have been placed under temporary administration. It started from 2 companies from the energy sector. And according to Russian authorities, they have a great importance for the stability of Russian economy. That's why such measure has been taken. However, there is also an opinion that these companies were placed under temporary administration in response to seizure of assets, of Russian assets abroad. Then in summer 2023, further 2 corporations, this time from food industry, have also been placed under temporary administration. And finally, in September, another joint stock corporation owned by Norwegian media holding company received a temporary administrator, temporary manager. And this list, of course, can be broadened, but only with the respective decrees of the President of the Russian Federation. It also should be mentioned that the owners of all these companies, in some way or another, announced their plans to leave the Russian market. Now, any Russian assets of so-called unfriendly foreign persons, both individuals and legal entities, can be placed under temporary administration, but currently it mainly concerns, of course, shares and stakes in Russian companies. Such measures can be taken if there is a deprivation of Russia or Russian persons of the property rights abroad, restriction of such right, or threat of such deprivation and restriction. And also if there is a threat to the security of the Russian Federation or its defense capability. Temporary administration is introduced and terminated by decrees of the Russian president, and it is financed at the expense of the income from the use of the very foreign assets that are placed under temporary administration. Mainly Rosimущество will be temporary manager. However, President of Russia can also appoint any other person, both individual or legal entity. And such temporary manager will be conducting an inventory of the foreign property, ensuring its safety, and have a right to possess and use this property. However, there is no right to dispose of assets, so temporary administration, temporary manager cannot sell stakes and shares or somehow alienate them. And Rosimущество constantly stresses that this measure is of temporary nature and that temporary administration doesn't equal nationalization. Well, at least from the legal point of view, it's true, because nationalization can be introduced, can be conducted only if there is a federal law, a corresponding federal law, and such law has not been yet adopted. So there is no legal prerequisites for such procedure, at least for now. Marina, your turn.
Yeah. So and now about the second law, which allowed to transfer the shares in the Russian companies with foreign participation to third parties by court decision. So recently came into force a law number 470 into force, allowing Russian beneficiaries of economically important companies with a foreign ownership structure to obtain direct control over them. This should solve the problem of loss of manageability of the business in Russia, or its ability to pay dividends due to the block of decision of the real owners by unfriendly governing bodies. The list of economically important companies should be formed by the government, by the Russian government, based on the revenue more than 75 billion rubles, or the number of employees more than 4,000, or the value of assets more than 150 billion rubles, or the amount of taxes paid at least 10 billion rubles. In addition to this criteria, the company or its subsidiary must be either a systemically important credit institution, or implement technologies and software for publicly important services, or participate in development or modernization of high performance or high wage jobs, or be recognized as a subject of critical information infrastructure or a city forming enterprise as of February 1st, 2022. Decision of the execution of foreigners from the chain of ownership will be made by court. It's next slide, yeah. We will made by court of the Moscow region, based on claims from state bodies or shareholders. The grounds are de facto cessation of management after 24th February 2022. It can be evidenced by public statements on cessation of operations, termination of material contracts, or cessation of their fulfillment, or reduction more than 1/3 of the staff, or compliance with Western Sanction and others. This mechanism applies to economically important companies where unfriendly shareholders or holding companies own at least 50% of such company, and the ultimate beneficiaries are residents or citizens of the Russian Federation. The ultimate beneficiary must get direct ownership of shares of the economically important companies. As there is no such possibility, for example, not all of them are residents of Russian Federation, the unfriendly shareholder is entitled to compensation. An economically important company that is not public company has to be transformed into public company if the shareholding company is also public. And experts assume that this law may affect, for example, Yandex or the pharmaceutical company Genero. Yeah, then now we are talking about some court cases with participation of companies with from unfriendly state. So the number of economic disputes involving foreign persons has sharply increased in Russian courts, while the overwhelming majority of decisions are made in their favor. It was reported recently by the chairman of the Supreme Court, Vyacheslav Lebedev. According to Lebedev, the number of economic disputes involving foreign legal entities in the first half of 2023 amounted to 10.6 thousand cases, which is 60% more than in the same period last year. At the same time, foreign entities won the overwhelming number of disputes, 93%. Disputes relate to challenging the action of customs, 52% were satisfied. Tax authorities, 49%, and so on. So, for example, 68% of application for recognition and enforcement of foreign judicial and arbitration decisions were satisfied, etc. The next slide, and now overview of court cases in Russia. Bankruptcy cases of foreign companies in Russia have appeared. Previously, there was no such practice in relation to legal entities. Court could only open bankruptcy proceedings against individuals, but now the courts initiate bankruptcy cases against foreign companies if they have the so-called center of main interest, COMIS standard, in Russia. This can be evidenced by the presence of property, accounts, clients, and management in Russia. Then disputes under supply contracts are related to the impossibility of fulfillment in connection with the Western sanctions. In such disputes, courts make different decisions depending on the circumstances in the case. In particular, the supplier's behavior is important. Whether they try to obtain permits for delivery from the local authorities, or whether they notified the buyer in a timely and regular manner about postponement, whether they applied for a certificate of force majeure, or whether they offered to extend the delivery term, whether they tried to find a replacement for the equipment, whether the equipment was unique, and so on. Accordingly, the provisions of the contracts on force majeure, on the right of unilateral withdrawal from the contract are investigated. Quite often, the courts have considered application for a prohibition to hear disputes abroad under new Article 248.1 of the Arbitration Code, despite the existence of an arbitration clause in contracts. The courts believe that any Russian person can use this article regardless of whether or not they are under personal Western sanctions. The court believes all Russian people have difficulties related to Western restrictions, paying foreign courts fees, obtaining visas, crossing borders, getting assistance from foreign consultants, etc. And the courts apply this article not only in disputes with foreign unfriendly companies, but also with friendly companies, country parties, if the court is located in the territory of the unfriendly country. In case of recognition of foreign judgments, court checks if there is an interstate agreement on mutual legal assistance between the states. If there is no such agreement, they apply the principle of reciprocity. The fact there is a relevant foreign state recognizes the decision of Russian courts. For this purpose, applicants submit evidence of such recognition to the court. Now the trend is that courts require proof of reciprocity after February 2022. If previously foreign courts of relevant country recognized Russian court decisions, but after February 2022 they did not, or there is no such practice, Russian courts assume that reciprocity has not been proven. There is also an interesting court practice of excluding foreign participants, shareholders from Russian joint ventures. A court decides on a claim of other Russian shareholders to exclude a foreign shareholder from the shareholder list. The other shareholders, or Russian shareholders, claim that the foreign participant did not properly fulfill its duties, did not participate in general meetings, and so on. Such a decision is the basis for changes in the register of legal entities or the register of shareholders. It is noteworthy that the foreign participant recognizes the claims for his exclusion, and the second point is that his withdrawal does not require the approval of the subcommission. So, and there is also some court cases now about against foreign companies that refused to localize personal data of Russian individuals in Russia. Among them are Google, Spotify, Airbnb, and etc. And Maria will speak about the challenges of transactions by the prosecutor and the transfer of shares into state ownership.
So there is a recent court practice of recognizing transactions to acquire control over so-called Russian strategic companies as void if the stakes and shares in these companies were purchased by foreign investors or a member of a group of entities with a foreign investor. And normally such transaction needs a permission of the government commission. If such permission was absent, then the transactions can be challenged, and they are in fact quite often challenged as of nowadays. Recently, it was mainly by Federal Anti-Monopoly Service, but since October 2022, Russian prosecutors have also been given such powers. So when we are talking about strategic companies, we mean Russian companies of great importance, of strategic importance for national defense and state security. They are normally engaged in certain types of activities. So judging by the case law, most of these activities are somehow connected to the military equipment, to the nuclear industry, such areas of economy. But there are also a lot of Russian ports holding dominant position on the market. And the transactions with stakes and shares of these ports have also been challenged. And also there are several quite innocent and peaceful activities, such as catching of biological resources or printing business. However, transactions with the stakes and shares in these companies can and are also challenged as well. And when we are talking about the control of the foreign investor, it's meant ability to directly or indirectly determine the decisions made by the company. It can be either by disposing of votes at general meetings or by participating in management bodies, or so on and so on. So that's an open list. And having analyzed the court's practice, we've highlighted several arguments of the defendants and the reasons why they were rejected by the court, and why the shares and stakes in strategic companies have been alienated from their foreign shareholders. The first argument is that the period of limitation has expired because, according to Russian legislation, these periods amount to 3 years, and most of the transactions have been made in 2010, 2013, or 17. However, according to the Russian courts, the limitation period runs from the moment when the applicant, which is a prosecutor or the officer of Federal Anti-Monopoly Service, so when the applicant became aware of the transaction due to the audit or some such measures, or of who the defendant was, the defendant or the company, or the defendant or foreign investors. The second argument is that the company is not of strategic importance or doesn't hold a dominant position on the Russian market. However, the Constitutional Court of Russia thinks that the status of the strategic company is determined exclusively by the courts or based on their discretionary powers. And most often, it doesn't even matter whether the particular activity is on the list in the trade register, or whether it's main activity or additional activity. So when there is a license for some activities, for example, for catching the same biological resources, the company can easily be called as strategic. And talking about the dominant position, its existence normally proved by the Federal Anti-Monopoly Service, and the court doesn't hold this agency to a high standard of proof. So they normally don't even analyze the state of competition on the market. They just state that the company is dominant. And the last argument, that the strategic company was not controlled by foreign investors, or that the beneficial owner was a Russian person. However, in all of the cases, court held that Russian persons either had dual citizenship or were members a group of persons with foreign investors. For example, they either held managerial positions in foreign companies or were married or related to a foreign person. And normally such transactions, as I already mentioned, they could not be conducted without permission of the government commission. And if they were in fact conducted, the parties have to return everything they received under the transaction to each other. And if it's impossible, to receive a monetary compensation from each other. Federal law on strategic companies also adds that if such bilateral restitution is impossible, then the foreign investor is deprived of its voting rights. However, Russian courts claim that such transactions are contrary to the legal order, and they recover the shares and stake in strategic companies to the ownership of the Russian state. So, in essence, foreign assets in strategic companies have been seized, and even though it wasn't even provided for, such measure wasn't even provided for in the federal law on strategic companies. However, in April 2023, the amendments were made, and now this became possible in case of a willful transaction made without the permission of the government commission. Olga?
Olga, unmute your microphone, please.
Yes.
Okay.
So, and also we have tried to summarize the recent changes that affected taxation on the territory of Russian Federation. So as was mentioned before, on the 1st of July, Russian Ministry issued so-called list of unfriendly parties, and these unfriendly parties are treated, were considered as offshore countries with appropriate consequences for taxation. And first implication is transfer pricing. Deals with countries from this list are considered as controllable by default. So no criteria of related parties will be applied. So what does it mean in practice? That if we have transactions with country from this list, so upon reaching the limit of 120 million rubles, company will have to submit notification on controllable transaction. And as a result, tax office will have extended possibility to check this transaction. And if necessary, if tax office finds the prices of this transaction are not fair, are not marketable, tax office has rights to accrue additional taxes. Another implication relates to register of small and medium business. Companies from this list potentially might be excluded from this register after July 10. So practically a company will lose tax benefits. First of all, reduce tax rate on social taxes. The good sign that at the moment we don't know about the casing of exclusion from this list. So it's really good. Masha, next slide, please. The another applications is no zero tax rate on dividends from foreign entities. And also no 0% tax rate on the sales of shares and stakes in foreign entities. And shareholding over 5 years does not matter in these cases. These changes affect Russian entities, Russian businesses who own stakes or shares in foreign entities. But the next, Masha, next slide. But the next slide, will will show consequences which is I would like more painful for business. First of all, transfer of property and rights. Everybody knows that previously parent company could donate, could transfer property or property rights free of charge. So no income tax was charged. But now, no zero tax rate on these donations, these transfers. Also, no free taxation for active foreign and holding and subholding companies. Masha, next slide. And also in August this year, President issues decrees, where a double taxation agreement with companies from this list were temporarily stopped. And this the common we have summarized the common things for almost each company. First of all, dividends. So no reduced rate, no zero rate. All dividends are subject of 15% taxation. Also, interests, no, for some European countries, payments on interest was treated like zero taxation. For Belgium, it was 10% taxation, and it was unlimited allowance for CTA. So this condition is not valid anymore. So royalties, no free taxation. When we pay royalty, we should pay 20% income tax from each payment of royalty. Profit for international carriers, also no free taxation anymore. And what relating construction sites, the free period of 12 months, is also not valid anymore. And Masha, next slide. And now, our government introduced such restrictions, probably decided to soften somehow the effect of these restrictions, and now issued draft law, draft amendments into tax code. And what are proposal for tax code? First of all, no taxation for payment for interests for foreign banks and export credit entities. Royalties for program products and for immaterial assets, also will be taxed at zero rate. And lease of aircraft, air engines, and supplementary power machines on contracts before March 5, year 2022. Sale of marine vessels, and also sale of sport and entertainment broadcastings. So all these payments, will not be taxed on the territory of Russian Federation. And which warning, which limitation we see here. First of all these payments should not be with related parties. What does it mean? Yeah, if we pay for royalty for parent company, for mother company, we will not get this exception. Yeah, so royalty for parent company will be taxed. What else? Not all. It looks like that our government intends to stimulate separate areas of economic, not all. Yeah. So while they release only sale of marine vessels and the lease of aircrafts, only. The changes does not matter for international transportation, for freight of sea vessels and containers, and a very, I would say, tricky wording in terms of royalty, because there is a special notification that these products shouldn't have a similarity with products existed in Russia. So my question is, who should prove the unique of royalty? Because in my opinion, all royalty are already unique, and I don't know who will define the similarity. Similarity exists or not. Tax office or taxpayer should provide this similarity. So as you can see, the scope of proposals are quite short, and wording is tricky. And the last slide, probably Marina, who will continue. Marina, microphone.
So this slide is our final slide, and with risk mitigations recommendation. And we would like to summarize all things we have said today. So it's important to know that Russian companies which are under control of the so-called foreign states, that they should follow all the sanctions rules, from Western states and from Russian states, and it's important to check whether operation transaction in Russia met all requirements of Russian Russian anti-crisis measures or counter-sanctions measures. And sanction compliance is very important now, and each adaptive strategy should be checked, from this point of view, sanction compliance. It's important also to check IT infrastructure and also personal data treatment, because now we have at least 12 cases in Russian courts about violation in this field, personal data treatment and keeping of personal data in Russia. And also we recommend to check all the provisions in contracts about force majeure clause, and to introduce or to include this clauses in your contract in the future, because it's also important by the court, and it's really good if it's in favor of that company which included such provisions, such clauses in their contracts. And it helps now by court hearing if such provisions are in the contracts about force majeure.
Dear colleagues, I would like to thank you. And first, I would like to say that I was surprised to learn that many new things which appeared recently in Russian legislation. But in the same time, I have first question. I will close probably the recording to continue to be not stop recording. Where is it? Apologize. I cannot find the button. Just a second. Share. Well, stop recording. Stop record. Are you sure you want to?